Let's discuss the trial then with the legal expert Mpumelelo Zikalala, who joins us now just to unpack what transpired in court today. Of course, that is the Free State High Court. Mpumelelo, a very good afternoon to you, and thank you so much for your time. So just help us unpack then, the application and the concerns by Bester's new lawyer, Advocate Lerato Moela, including, of course, their submissions around concerns raised by Bester's receiving a fair trial when it does happen. Also, while all the lawyers have confirmed that they will be ready, or should be ready, in fact, for the trial, Advocate Lerato Moela says they will not be.
Good afternoon to you and also to your viewers. Basically, in any pre-trial proceedings, that's when you say, I want to check the state of readiness when it comes to you going to trial and be able to defend your client. Now, in this case, Bester and his lawyer were saying, we've not been able to reach the state because I can't consult with my client. And reading in between the lines was to say even the state of his mind is not one or an individual that can be able to give out proper instructions, and they need time in order to go through the evidence and access to laptop and other utensils so that they can be able to formulate their own defense. So that was the basis of it in terms of coming to the court and saying, we want to make an application in which an order will then be issued saying that we must be eligible or be given these utilities or these tools so that you can be ready for trial at a later stage. So that's why you had that back and fro in terms of the judge saying you have an application which is before me which is not proper, not because it is wrong in merits, but because there are certain things that are missing. And I can't adjudicate this matter at the moment. And you seem to be conflating two things, the state of readiness of a particular trial and the manner in which a person has been detained, which it must be dealt with in a completely different forum.
And I mean, just talking about, what we are seeing outside of that case with these media statements being released by Bester's camp, and then, of course, the Department of Correctional Services responding to some of those claims that were in that submission. Firstly, the Department of Correctional Services has basically rubbished, Bester's claims that he's kept in solitary confinement 23 hours of the 24 hours in a day. They've also said that they are treating him with heightened security, which is consistent with the Correctional Services Act, and also given that the fact that he escaped from the Mangaung Correctional Center. I mean, how does this rebuttal, so to speak, in response to Bester's submission, and how will it be weighed in court, if it will be?
I think it would depend mostly on what is written in the affidavits between the two parties. What matters at court is that what has been stated under oath and something that can be vouched for to be the truth. Anything which is stated outside of those court confines, yes, may be considered, but there's not much weight that has been placed on it. But look at the two sides. You have the side of Mr. Bester saying that I'm being treated in a bad manner. You have the side of the department saying that we have a duty as Correctional Service Department to run a prison facility. There are going to be rules and regulations in which you must be adhered to. And one of those is that once we have branded you as a person who is a higher risk, there's a certain focus that must be given to you and a certain manner in which we must treat you in. So you're not going to have special treatment just because you are a staff. Everything that applies to every other, coming back to how the court evaluates it, then the court says, in normal circumstances, in a manner in which we are within balancing all those rights, how do we do it when we need to defend your rights as an inmate? We must make sure that you have access to legal rep. Yes, you have that one. Let's tick that box. Secondly, have you been given enough time in order to consult? Have you requested time within the correctional facility? If not, come to court as if you are going to hear the trial, and that particular day is going to be given to you so that you can be able to discuss the matter with your attorney or your legal rep, and then you can be able to formulate a defense. But what can't happen is for you to be given a special dispensation or special requirements just because it's a high-profile matter.
Mpumelelo, your network recovered in the tail end of that response, but let's see if we can just forge ahead. I want us to now unpack another dynamic that was raised, of course, by Dr. Nandipha Makutumane's attorneys, and it might also just be another dynamic, within this particular case. The legal representative application to the Supreme Court of Appeal was brought up, saying that how would then the SCA's application affect the legal team's readiness? Because again, there is that question if everybody will be ready should this go to trial by next year. For instance, if the SCA decides to hear Dr. Mark Goodmana's application before the trial begins next year, how will then that affect, in fact, the readiness, firstly, of her lawyers and also the implications then of that particular application being heard?
I think that purely depends on her legal rep's availability in terms of dealing with these two matters simultaneously. But what I think would happen is that the only time in which there will be effect on any of the two proceedings is when there's an order or the court has decided on any of those matters. So let's say within the SCA, the court orders that the arrest was something which is unconstitutional and then the person should be taken away or that particular arrest should be put aside, even though they do have an opportunity of rearresting them because they haven't gone to trial as yet. So I don't think it's going to have that much of an effect in terms of the administration of the two processes. It's just that from the side of the legal rep, the judge was simply being cautious and saying, I do not want you to come back in February and say that you did not have enough time because you are concentrating on the SCA matter which is taking place. Give me the assurance that when you come back here in Feb, you would have been able to consult, gone through the statements that have been given to you, and you are ready to deal with the trial as it would have been said.
Just another dynamic. I mean, what happens then should she be successful in that appeal?
Well, it would mean that the arrest is then put aside, but separate the two instances. Separate the arrest and separate what you've been arrested for. So it can be that you are arrested in a manner that is unprocedural or unconstitutional, but it does not exonerate and make you free at the end of the day, or the merits of what you have arrested for being wished away as if you had never performed an act which is contrary to what the law is saying. So they may brand that particular arrest and saying that it wasn't okay, but it does not mean that they are not going to stand trial here. In fact, for me, when I was thinking about it, I said, why go through all this trouble when even after you have won, you can come back on the day, and then as you are walking out the courtroom, you are rearrested again in a proper manner now, but you still have to face the same charges.
Yeah, so the likelihood that you will then escape a criminal trial is very slim, as per your suggestion. But very quickly, Mpumelelo, before I let you go, these postponements, I mean, now we are likely to see this, pre-trial, as per se, go ahead next year only. I mean, how likely are we going to see this trial sometime in the new year?
I think maybe in the second half of the year, that's when you're going to see the trial actually starting, which is a bit of a long time when it comes to the administration of justice. But I'm worried about three things, actually. It's the quality and the quantity of the evidence which is going to be utilized, because people may end up passing on or dying. Documentary evidence may be lost, which you cannot be able to use either as the state, as the burden of proof beyond reasonable doubt that the individuals are guilty, or even from the defense to be able to exonerate themselves. But most importantly, it's the victims in this whole thing.
Yeah.
There's a person who has lost a son that needs answers, and the longer we wait up until we go to next year in Feb, it then means up until then they're not going to know what happened to their son, but most importantly, they're not going to see the law being on their side in terms of justice being given out, and for them being satisfied that they've gone to the law and the law has come to their side and provided the type of justice in which they were looking for.